Welcome to the other side of Lucy Letby. In episode 55, we're going to continue with this review of the Court of Appeal ruling, which denied Letby the right to appeal. But before we do, we'll have a look at an extraordinary interview that Dr. Evans gave to BBC Radio Wales. And this was the BBC asking Gary Evans what he made of Sir David Davis' call for a retrial in her case. Gary starts off and he answers the question by saying that he thinks a new jury would find her guilty quicker than the old jury. And then to back this up, he cites the usual stuff that all the evidence in the original trial is untainted in any way. And he goes on about the usual, that the evidence was given by nurses looking after babies, doctors looking after babies. And it seems extraordinary to me that Gary Evans is impenetrable to anything other than the product of his own ego. He doesn't mention, or he doesn't want to go near, even the genuine controversies that have arisen since Letby's conviction. The extraordinary revelation about the death of baby O and the puncturing of the liver by a cannula as the reason for that, rather than the improbable external trauma and our embolism that he said Lucy Letby did to baby O. We have heard no denial of this from Dr. Stephen Breary, the consultant said to have carried out this ill-advised procedure. And we have no comment from Gary Evans as to why he didn't mention this in his so-called expert report. There's no way on earth this could be seen as an understandable oversight on his part. Such a serious matter would likely have been investigated properly in a coroner's court, but was essentially ignored by the experts in the Operation Hummingbird report. And in fact, all the experts went to extraordinary lengths to avoid putting into evidence that baby O and baby P had been overventilated from the beginning, which was the actual cause of their destabilization, and that baby O had been indeed the subject of trauma, but iatrogenic trauma. Gary doesn't seem to understand that since he claimed in court that baby C was destabilized by injection of air into the stomach, but that occurred on a day that Lucy Letby wasn't there, he either has to remove that as a cause of harm to babies, or he has to say that there was another nurse in the Countess of Chester Hospital that was harming babies by this method. In the case of baby F, the insulin case, he has to deal with the fact that the blood sample, the only blood sample that was analysed, albeit in two different laboratories, gave a verified reading of 999 millimoles per litre of glucose. And by verified, what I mean is that a lab technician has run the test, and the senior technician in the laboratory has looked at his methodology, checked the test, and verified that it was done correctly, which leaves Gary with a big problem. He claimed that baby O had been poisoned with insulin, and that the insulin had caused, as it would, hypoglycemia or low blood sugar. Yet the blood sugar from the sample taken as a proportion of the total sample, single sample, from BBF at that time shows the opposite, that the blood sugar was 999 off the scale. So the blood sugar of 999 along with the insulin of around 4,600 picomoles per litre are incompatible. They cannot happen together. It is impossible. Not implausible or improbable, impossible. So one of those readings has to be wrong, and that perhaps might be okay in a clinical situation where the information was really important. But it's not okay for a trial, because all of the tests that were taken from that single sample, and that included many things, some of which are normal, some of which are abnormal, are essentially tainted, something which a new jury is going to have to deal with. The swipe data, which showed Lucy Letby to be in places where she wasn't at the time of these incidents, and the alternative route around the neonatal unit from a back stairway that didn't have any swipe data and could have been used by anyone but was not mentioned in court. The people who worked with Lucy Letby, who wanted to give evidence on her behalf, but were dissuaded from doing so by NHS management, they will now be in the frame. The contamination of the ward by Pseudomonas, at least Pseudomonas, we don't know what else it was contaminated by. That wasn't mentioned in the trial, but it would have to be mentioned in a retrial. The vital blood gas machine that was broken for practically the whole time, 2015 to 2016, and which gave inaccurate readings of saturation of oxygen in these babies, which were a vital part of the evidence for the prosecution when they claimed that all of these babies were stable. It turns out that a lot of the data used by these people to make that assumption was incorrect, and that for the most part they were relying on capillary heel pricks, which the experts in the trial, including Darry Evans and Sandy Bowen, said were insufficient to determine the oxygenation of babies in the neonatal ICU. In the interview, he sounds actually quite flat to me in his affect. He's not his usual combative self, but he remains his usual dogmatic self. He's not going to change his mind no matter what. And rather than use BBK as an example of almost being caught red-handed, which turned into an utter debacle and caused one appeal court judge to put a question mark over the reliability of Dr. Jairam, he instead now uses the confusing evidence of the mother of baby C and said that she almost caught Lucy Letby red-handed. But he seems not to know that there is some controversy about the timing of this in relation to British summertime and the fact that in the UK, watches would go forward by 1 hour, but the data kept by the mobile phone companies, which the mother relied on to time her phone calls, wouldn't go forward by 1 hour. So this would put Letby's timing or memory of the timing of the meeting at 10 p.m. and not 9 p.m., as the mother said. In any event, as I pointed out, the first vomit of blood from baby C was very bilious and dark, meaning it was old blood, not new blood, old blood, many hours old. And it occurred in baby C before Lucy Letby was on shift. Darry doesn't want to know that either. Darry also uses the fact that there was no defence expert put into evidence, which again is a misunderstanding of his own role. In British law, there are no defence and prosecution experts. There are experts who aren't meant to disagree on fundamental matters of science. They may be able to interpret the findings differently or put emphasis on one or the other slightly differently, but they cannot fundamentally disagree, as we will discuss. Evans also actually says in this interview that he thinks that the evidence against Lucy Letby is actually stronger than it was 2 years ago, thanks to the output of the Lady Thirlwell inquiry, when the truth is that the opposite is actually true. And a lot of information that wasn't available to the jury is available to the jury now because of the Thirlwell inquiry, including the fact that Dr. Breary, clearly states in his email to Dr. Gibbs and Dr. J. Ram and others that baby D died from sepsis as a result of pneumonia, something which was denied by the experts in court, but confirmed by post-mortem. And we have to remember, post-mortem is the gold standard for finding the cause of death. Everything else, including opinion and theorizing, are pale shadows compared to post-mortem, none of which actually seem to make their way in completion or in any kind of logical form into the evidence of a murder trial. That would not be the case in a retrial. Operation Hummingbird could only succeed by ignoring the gold standard findings of the post-mortems. Dowie doesn't seem to get this, and there would be a legion of people willing to give evidence on her behalf now in a public arena, as he calls for, but he wouldn't be one of them. And one of the reasons that the Court of Appeal didn't throw out Dowie's evidence was because he had apparently, at least according to these judges, he had picked up on the so-called insulin cases. That's BBF and BBL, which I've already said are problematic. And the problem with BBF and BBL doesn't just go to the substance of Dowie's diagnosis, it also goes to the method. And in the Criminal Procedures Act, Section 111D, establishing method or methodology while creating evidence is a critical part of that process. And thanks again to the Lady Darwell inquiry, we now know that there were 3 insulin cases. Yes, Dowie and Professor Hindmarsh found 3 insulin poisonings, all by the same method. The core of their method was the finding of an elevated insulin and a suppressed or absent C-peptide. According to these experts, that's all that's required on one test to prove insulin poisoning, which is so far below the reality of any forensic standard that it's inconceivable to me that this ever made its way into a criminal trial. But the problem for Dowie and for Professor Hindmarsh is that one of the 3 that they found didn't make its way into a criminal trial. So even though the methodology was the same and the conclusions of the experts were the same, meaning that if one baby was poisoned, all 3 babies were poisoned, Letby or no one else was charged with the 3rd baby. That is something that has to be addressed. And what was more disturbing about the case that didn't make it to court was the measurement of the insulin. Despite the fact that the measured insulin was so high that it was beyond the measurement range of the machine or the analyzer, meaning again that the result was not reliable, expert Evans and expert Hindmarsh still said that it was a case of poisoning, which to me raises serious doubts about their method or methodology, and thus the reliability of any scientific inference from that data. So I think if Dowie thinks that it would be easier to lock away Lucy Letby than it was 2 years ago, I think he's a tad deluded, for want of a better word. Now, I've just given a few things. There are many, many other things going on in the background. We will have new reports soon. We will have, I've no doubt, published reports soon. So I would say to BBC Wales, keep Dowie in your phone book and watch this space. So before we get to paragraph 111, which is where we left off at the last podcast, that was ground 1 discussion. There was one thought I had, but I forgot to put it into the last podcast. And it's to do with the letter that Justice Jackson wrote to the court, as I understand it. And it's also related to the credibility of Derry Evans that we've just discussed. Now, you will recall that Justice Jackson wrote to the court and told them that, in his opinion, Derry Evans was not someone who was suited to being an expert witness for various different reasons. And Derry seems to forget that the prosecution in section 103 or paragraph 103 did not oppose the admission of Jackson LJ's decision, but again submitted it was material to the weight to be attached to Dr. Evans' evidence. So this is just more legal claptrap as far as I'm concerned. They don't oppose a letter that is damning of Derry Evans from another senior judge, albeit on another matter, but they think that this should be something that the jury decides on. So again, I ask the question, what is the point of the procedures, the pretrial procedures and the rules of evidence? Who made the determination that Evans' theories on causes of death for these babies that ran contrary to the gold standard method of determining death, autopsy or postmortem examination? How was the Derry Evans method assessed beside the reliability of autopsy? I don't know, and I've never heard anyone ask that question. But the judge did allow Justice Jackson's letter to be adduced, that means accepted into evidence as part of the trial. So Justice Jackson's opinion of Derry Evans as an unreliable witness is part of the evidence of this trial. And we need to jump forward a little bit to paragraph 122 to find what I think is a bit of a problem with the judge's ruling on the admissibility of Evans' evidence. In paragraph 122, it says, we should note finally that after the judge's ruling on January the 10th, 2023, Dr. Evans was asked about the observations of Jackson LJ in cross-examination. The effect of Dr. Evans' evidence, and we summarise, was that the criticisms made in the decision were based on a false premise. The report was not an expert report prepared for the court or a witness statement. Rather, it was a letter to the solicitors in the Kerr case and had been used by the solicitors for the purpose of the application for permission to appeal without knowledge or consent of Derry Evans, and further that he had not known of the decision before it was brought to his attention by the prosecution. Everyone in this trial, that is, that of the applicant, had seen the decision before he did. So let's look at what that really means and how much of a pass I think it gives. Derry Evans was obviously asked by a solicitor in the course of events to apply a report to him with regards to the safe custody of a child in care. The judges said that this was merely a letter, that it was not a report prepared for a court, but only for the solicitor's information. And it was, as I understand it, Justice Goss's opinion that the criticism of this letter was based on a false premise, because the report was not intended for court, but ended up in court. But that does not diminish the seriousness of Justice Jackson's opinion of Dr. Evans. If you read Justice Jackson's letter, it is contained, as I see it, in two parts. Parts that refer to the letter itself, and parts that quite clearly refer to the writer of the letter itself, Derry Evans. And what Justice Jackson wrote was, finally, and of greatest concern, Dr. Evans makes no effort to provide a balanced opinion. He either knows what his professional colleagues have concluded and disregards it, or he has not taken steps to inform himself of their views. Either approach amounts to a breach of proper professional conduct. No attempt has been made, which can translate in proper grammar is Dr. Evans made no attempt to engage with the full range of medical information or the powerful contradictory indicators. And then we return to the report. Instead, the report has the hallmark of an exercise working out an explanation that exculpates the applicant. It ends with tendacious and partisan expressions of opinion that are outside Dr. Evans' professional competence and have no place in a reputable expert report. And I think the judges are getting caught up a little bit here in the difference between the law and ethical conduct or obligations of a doctor. I don't think it's possible for a judge to express his contempt for the person, Dr. Evans, as Justice Jackson did. When he referred to Darry Evans as he was referring to the person, Darry Evans, not the letter written by Darry Evans. And what were Darry Evans' obligations as a doctor when writing the report? No matter where it was going to end up, whether it was going to be in court or not in court, his obligation was primarily to the patient. What was the best decision for the patient with regards to this report? Could his opinion in this letter, whether a report or not, have an effect that might lead to an adverse outcome for the patient? It seems to me that Justice Jackson certainly felt that was the case. And again, it doesn't matter if a doctor writes a report that goes to a third party. No matter what the intention of that report is, for background information or for use in court, it still has to be accurate, truthful, objective, and impartial. It requires you to clearly state the basis of any opinions given, which is clearly what Dr. Evans didn't do. It obliges you to remain within your area of expertise, which Justice Jackson claims Evans didn't do. That is a criticism of Dr. Evans, not a criticism of the report. You're meant to keep very detailed records of any information that you use when you're compiling these reports or opinions. And whether or not it goes to court, you must prepare yourself to justify the conclusions that you have given, which Justice Jackson claims Darry Evans didn't. So it seems to me that the judges here in the appeal court don't really know what the obligations of a doctor are. And I would argue that they haven't given sufficient weight to Justice Jackson's letter. And they have confined their opinion of it to the circumstances around which the letter arose, and not, as they should have, to the author of the letter. Over the course of my working life, I wrote hundreds of reports for all kinds of people. The first thing you needed was consent of the patient. The second thing was that you had to tell the patient that they had to be honest and that you had to be honest on their behalf, so that you would be encouraging the patient not to hold back anything that should rightfully or fairly be information needed by a court, arbitrator, employer, or whoever had asked for the legal report. And very often, a situation would arise where a person, the patient, did not want the doctor to forward information. Now, sometimes this was clearly a breach of your obligation to be honest. For example, it was not uncommon for people who were in road traffic accidents, for example, or industrial accidents, to ask me to hold back information about old injuries that they had, which would be very dishonest. Then you're into a situation of, I can't do that. And sometimes that can turn nasty. But the fact is, you can't do that. You simply say to the patient, I can't write the report if that's the way you want me to write it. You are free to find another doctor who might write it for you. But I hope you can't, because it's against the spirit of the doctor-patient relationship, which is open and honest on both sides. When Justice Jackson used the word he in his report to the court about Darry Evans, he wasn't referring to that letter. He was referring to that man. It was Justice Jackson's opinion of what this doctor was capable of and willing to do. And whether or not that's in an official sworn statement to the court or any casual opinion, the standard of truthfulness and honesty, impartiality, and the interests of the patients remain the same in every circumstance. In my opinion, this was a damning letter about Darry Evans. And to show you just how dogmatic Darry Evans was, in court he said that he thought it was actually a good report, contrary to what the judges, the appeal court judges and Justice Goss said when they allowed the report to be used in evidence so that it may affect the weight of Darry Evans' evidence rather than its admissibility. It follows that, in essence, they did not disagree with Justice Jackson's opinion on Darry Evans, the man, as well as Darry Evans, the non-report report. When it goes to the heart, being a doctor, they're one and the same. If you put your name to anything, it has to be true to the best of your knowledge, and it's critical in the interest of the patient and in the interest of justice that you cooperate with colleagues, even if they have different opinions to you. And the opinions usually vary on the basis of weight. For example, if there is clear evidence of neglect of a child, it doesn't matter where that neglect came from or which adult was responsible for the fact that it happened. The obligation to the patient is to remove them from the area of threat, after which time decisions about the future are made. And why do I think that this is particularly important in this case? Because when we're talking about admissibility, we're supposed to be following rules that ultimately lead to fact creation. And the evidence that Darry Evans put into the trial with relation to particularly air embolism and injecting air and or fluid into nasogastric tubes as a means of harming babies are so off the farm in terms of the method of reaching conclusions in medicine that they ought to be inadmissible on that basis alone. Evans syndrome, as I'm wont to call it, which is a sudden collapse of a very stable preterm baby who has just come into the world, accompanied by non-specific skin discolorations that are nothing more than signs of shock for any reason, and the disregard, as Justice Jackson says, for the opinions of his colleagues. In other words, the findings of the gold standard autopsies. Darry Evans reached that previously non-existent syndrome not by use of the normal methods used in medicine, autopsy, but through the work of his own imagination. And he continuously refers to it, as he did in that interview with Radio Wales, when he said that air injected into the stomach or into the skin are options, one or the other, which is frankly not what he said in court, and therefore goes to the heart of his methodology. If Darry Evans was using a method to reach his conclusions, the method should give him the same conclusions each time and not cause him to change his mind during the trial or after the trial. And no matter what he wants to say, changing your mind on the mechanism of death in a pathology report is so profound, it negates the entirety of your report. It is no different than saying to the police, you know that guy I said that was shot? I've changed my mind. I don't think he was shot. That is precisely what Darry Evans is doing. He has changed his mind from this baby died because Lucy Letby put air into a nasogastric tube to this baby did not die because Lucy Letby put air into a nasogastric tube. Forget about the air, forget about the nasogastric tube, and just think of it as a bullet from a gun. I told you Lucy Letby had shot this baby. I'm now telling you she didn't. There is no fundamental difference in what he's saying by introducing options into his mechanism of death. Where should that leave the admissibility of his evidence now? In the light of what Darry Evans has said since the trial, how does his reliability stack up now? he is clearly not reliable if he's changed his mind, because the definition of reliability is that you don't change your mind. So again, I would say that Darby Evans' theories don't stack up to analysis when viewed at from scratch. From the insulin cases through to the air embolism cases, through to the injecting air into the nasogastric tube cases, there are multiple, much more likely reasons that he ignored but did not discount that explain why all of these babies died and or collapsed. So getting back to 111, paragraph 111, as we pointed out below in relation to grounds 2 and 3, there is a substantial degree of overlap between the grounds of appeal advanced by the applicant, save for ground 5, which raises a discrete jury management issue. This is because the first 3 grounds of appeal are essentially rooted in 2 related points: the bona fides of the prosecution expert, in particular Dr. Evans, and the quality of their evidence, in particular about air embolism. No criticism is made of the summing up of this case. It follows that, subject to the overarching contention by the defence that parts of the prosecution evidence should not have been left to the jury at all, the strengths and weaknesses of the prosecution evidence, as it is said to be, and more particularly that of Dr. Evans, were fairly set out and left to the jury in appropriate terms. So again, we're getting into the law rather than the force of an argument. I say, and many other doctors will say, that Darby Evans' logic is 1 + 1 = 3, because the advocate, Mr. Myers, a lawyer, did not disagree with the summing up of the prosecution, a lawyer. Darby Evans and the other expert evidence still remains 1 + 1 = 3. In paragraph 112, with respect to Mr. Myers, it is unarguably the case that Dr. Evans was suitably qualified, or to put it another way, it is not arguable that he lacked the necessary expertise to give evidence. So 1 + 1 still equals 3. This is the case whether one examines his professional qualifications and background or the evidence he gave about this during the course of the trial. So that's 1 + 1 is still equal to 3, because we're still arguing about whether Darby Evans is suitably qualified to be a witness. In paragraph 113, a summary of the evidential position is as follows. Dr. Evans qualified as a medical practitioner in 1971. He trained in paediatrics in Swansea, then in Cardiff and Liverpool. Each phase of that training involves specific training in neonatology and working in a neonatal unit. He was appointed a full-time clinical consultant paediatrician in Swansea in 1980, a position he held until 2009. During the 1980s, he became involved in the development of the newborn services and intensive care services for babies. He was responsible for setting up, supervising and leading a neonatal intensive care service in Swansea from his appointment, developing intensive care services from scratch. His experience was, he said, very much hands-on. In 1990 in Swansea, the Health Board built a new children's department, which included a new neonatal unit, which he helped to design. His operational and managerial roles involved serving as clinical director in paediatrics and neonatology in Swansea between 1992 and 1997 and between 2004 and 2008. In his evidence, he said that Swansea was one of the bigger units in South Wales, and it covered the area of the whole of the southwest of Wales over time. He had training in neonatology. When he arrived, there was no specialist neonatology services at that hospital, and it was just a question of getting on with it. His team had to deal with all the babies in the catchment area. The only babies who were sent elsewhere were those requiring surgery, who went to Cardiff, or those requiring cardiac care, who went to Bristol. So all of the tiny babies who required intensive care were under my care and the care of my colleagues in Swansea from 1980 onwards. So that's Darby's curriculum vitae, which is an ad hominem report. That is, it's evidence about Darby Evans, which still leaves us with 1 + 1 = 3. Paragraph 114 In cross-examination, as in his submission to us, Mr. Myers did not dispute that Dr. Evans had extensive experience, but Mr. Myers put it Dr. Evans as his experience or experience in the field of neonatology was less than that of a consultant neonatologist. Dr. Evans did not accept this. Of course he didn't. He said in the 1980s when he started out, neonatology was a relatively new discipline, and there were relatively few neonatologists. As a paediatrician in Swansea, he served a large population and was one of only a few consultants. Hence, his hands-on experience was extensive and full-on, and he had greater contact with a greater number of babies. His generation was responsible for the development and evolution of neonatal care in the United Kingdom, and the local health boards deferred to him in developing the service and in appointing and training the relevant staff. He had retired from practice in 2009, having been a consultant paediatrician, therefore for 30 years. Since then, he had worked as an expert witness, having attended a number of courses to equip to perform that role, and dealt with a large number of cases where there were allegations of clinical negligence involving small babies. He said he saw his role as providing assistance to the court in sorting out some extremely challenging issues. He did not call himself an expert, but an independent medical witness whose opinion was based not on being an expert, but on being a doctor. Well, I've been a doctor for 40 years of my life, and I've been involved in courts, family courts, civil courts, criminal courts, but I've never once been part, if not even the core, of a police investigation. And I don't know any other doctor who has. So, no matter what the Court of Appeal might want to say, Darry Evans' role in Operation Hummingbird was extraordinary. Again, more ad hominem stuff. How often are they going to have to say this? Dr. Evans is qualified to give an opinion. Nobody doubts that. But it still doesn't have any bearing on what he said. But by this time, it's obvious that it's too late for the defence. The nonsense that is Darry Evans' air embolism theory and nasogastric tube theory and insulin poisoning theory should have been stopped pre-trial at the evidence stage, and as well as expert opinion. The post-mortem findings, which are the gold standard for determining cause of death, should have been put into evidence as well. And then we get on to paragraph 116. As to the impartiality, the focus here is on Dr. Evans' role in the investigation. It is important to put this into context, however, a matter emphasised both by the judge and the single judge. I think the single judge is the second appeal court judge, or the first appeal that was denied. As the single judge said, there was a vast quantity of technical medical material which could not possibly be understood or evaluated without the assistance and appropriate direction of a properly qualified expert with forensic and clinical experience of such cases. There are plenty of such people in the state pathologist's office, and apart from having a few courses as a qualification in forensic medicine, Dr. Evans is not an expert in forensic medicine, which is a specialty in its own right. Within the space of a month that carries on in 2017, Dr. Evans provided initial SIFT reports in some 30 babies who had died or suffered life-threatening events at the hospital. This is very troubling because there is no way one doctor can provide 30 reports on the care of a preterm baby. So these reports cannot have been of a standard sufficient to draw any conclusion from, particularly as they had already been reviewed by pathologists, treating physicians, and had secondary reviews as well. It carries on. He then provided follow-up reports in respect of babies where there appeared to be no natural explanation for the death or adverse events. But for 6 of the babies that Letby was accused of murdering, there were natural explanations for the death or adverse events of the baby. They had had post-mortems, and some of them had had coroner's reviews. Essentially, what the appeal court judges are saying here is that we don't need to follow the normal procedure of autopsy and inquest. All we need to do is take 30 cases in a month and sift through them. I don't know by what methodology anyone would do that, and I can't understand why appeal court judges would not find this odd. There is a method to reviewing a case, and you cannot do 30 of them in a month by that method, meaning the sift exercise was by its nature biased. He produced some 114 witness statements plus a joint expert report dated 4th of September 2022. He identified air embolus, there's that word again, as a potential cause of death or collapse in several of the SIFT report statements. This is why this is very troubling. The single judge said, and we agree, that the judge was fully entitled, I presume that's Justice Goss, to conclude that the approach of Dr. Evans to his task was reasonable and did not amount to partiality or lack of independence, nor was it unreasonable for Dr. Evans thereafter to provide some direction and structure in relation to identified cases. To the extent that he was acting as an investigator or director of the investigation, he was not doing so in a way that precluded him from being an expert witness in the case. Well, all I can say to that is that whatever method Dr. Evans was using to sift cases, it wasn't a conventional medical method because it would take far longer than that. Let's look at this issue of air embolism one more time, and we will keep it very, very simple. No matter who does the sifting or who does the reviews or by what method they do it, we know from the body of literature about air embolism, and there is a substantial amount of it, that 90% of reported cases of air embolism in preterm neonates occurred in the context of assisted ventilation. 50% of those had some kind of air leak syndrome, such as a pneumothorax, which was the case of every one of the Letby babies. The most common presentation was a sudden acute clinical deterioration. That would be of preterm neonates on ventilation, sometimes accompanied by crying, cardiac rhythm abnormalities, skin discoloration, and decrease in end-tidal carbon dioxide concentration. Unfortunately, none of those are specific to air embolism, and therefore no one can diagnose air embolism from those findings. In order, therefore, to make a diagnosis of air embolism, we have to use one of the accepted methods or confirm one of the clinical findings that are specific only to air embolism. Therefore, we have to see signs of frothy blood in peripheral lines and maybe blood in the retinal vessels, and we have to have recognized radiographic confirmation of that, which we obtain from Doppler ultrasounds, transesophageal echocardiography, another type of ultrasound, or computed tomography, CT, none of which were performed on any of the babies said by Dr. Evans to have air embolisms. That is the methodology that he would need to use to come to that conclusion. It's clear, therefore, that he didn't use those methods to determine whether or not any of these babies had air embolism as a cause of death. They might have, but that was never properly determined. And even if it had been determined, the source of the air could not be distinguished or determined absolutely by any of these methods. The gold standard method or postmortem method of detecting air embolism is well established, and it is accepted that CT scans can identify the presence of air embolisms in the neonate, but cannot necessarily determine their origin. Therefore, in any situation where a baby is on mechanical ventilation or has external central lines running fluids into the body, that is the overwhelmingly likely source of air in that situation. And given that none of this information was available in any file that Darry Evans had because it was never carried out. We have to ask, what was his method of sifting? And if he's giving evidence in court under these rules of procedure 711, he has to provide a methodology. What, therefore, was the accepted methodology used by Darry Evans, both as an investigator and as an expert witness, to determine the cause and presence of our embolisms in any of these babies? Since he did not use the conventional techniques and methods, he must have used his own techniques and methods. And if he did so, then he cannot be an impartial witness to his own theory. And I would argue, therefore, that the judges are wrong to say that he was not doing so in a way that precluded him from being an expert witness in the case. We go to paragraph 117. It is obvious that wherever possible, objections to admissibility, particularly to expert evidence, should be dealt with before the evidence is given rather than afterwards. That is just a cold statement of fact, and I think it's a very reasonable thing for appeal court judges to say. They go on that the risk otherwise is that the trial process will be derailed. The procedural rules contained in what is now paragraph 7 of the Criminal Practice Direction 2023 are indeed designed to streamline the process for the admission of expert evidence and to minimize the areas of contention at the trial itself. It is to be noted in this case, however, that the application to exclude Dr. Evans' evidence on the grounds it was inadmissible was not made until partway through the trial. Again, that is a very reasonable point from the appeal court judges. This tends to suggest, the judges say, that the real bone of contention was not Dr. Evans' qualifications or competence per se, in brackets, matters that otherwise could and should have been addressed pre-trial, but concerned the way in which he gave his evidence. And on that point, I would have to depart from the judge's opinion. Was it not the duty of the judges to familiarize themselves with the methodology normally used to determine cause of death in preterm neonates? Are the judges aware of any situation or circumstance whereby the findings of postmortems are set aside in preference for a lesser standard of proof as to cause of death? Was it not possible, therefore, for the judges to look at Darry Evans' method and compare it to other methods normally used to determine whether or not an embolism is present? And let me give you an example. Here is a case report from 2015. A neonate born at term weighing 2.5 kilograms presented to accident in the emergency department at 5 hours of age with respiratory distress since birth. He was born through a normal delivery in another hospital and was diagnosed to have left congenital diaphragmatic hernia. After initial endotracheal intubation, resuscitation and stabilization, he underwent an uneventful repair of a small defect of diaphragm on the second day of life. No chest drain was inserted at operation to keep a small volume of pneumothorax to splint the left hypoplastic lung. So that's a sneaky little technique to brace the wound internally and provide a little bit of stabilization while it healed. Subsequently, he was extubated after 24 hours of surgery on day of life 3, and once the gastric aspirate cleared, started on enteral feeds via nasogastric tube. On day 6 of life, in the morning, he was self-ventilating on low-flow oxygen, tolerating enteral feeds via nasogastric tube at 50% of requirement. And in addition, he was receiving intravenous fluids via a 24-gauge peripheral cannula using an infusion pump, IMED registration infusion pump. A chest x-ray showed that most of the pneumothorax had reabsorbed, so as we can see, everything was going well. The baby was improving gradually, post-operatively, and it was beginning to establish feeds very well, decreasing the need for oxygen support, etc. However, in the same evening, he suddenly collapsed with cyanosis, bradycardia, and severe hypoxemia. Note no flitting rash, no discoloration other than cyanosis. Cardiopulmonary resuscitation was carried out with endotracheal intubation, but declared unsuccessful after 30 minutes. A chest X-ray was taken in search of etiology of sudden collapse after 30 minutes of resuscitation. This revealed significant volume of air in the right atrium, systemic and pulmonary vasculature. Not a line of gas, a massive amount of air in the right atrium and the great vessels, which is precisely what Dr. Arthur said was required to make a diagnosis of an air embolism from an X-ray. But the article goes on. There was no obvious cause of cardiovascular collapse in the baby. However, with the background of diaphragmatic hernia repair, gastroesophageal reflux could be a possibility. Isn't that very interesting? And the article continues, as autopsy is not the practice of medicine in Pakistan, many questions remain unanswered. However, one can argue possible causes of systemic air embolism in this patient. The possibility of this via 24-gauge peripheral venous cannula through automated infusion pump does not seem a practical possibility in the wake of massive air embolism, delineating the entire systemic and pulmonary vasculature. The automated pumps have built-in safety mechanisms to stop functioning in the presence of air bubbles, but there have been cases reported where alarms did not go off when the patient collapsed and could not be revived, and autopsy showed air in the cardiac chambers. However, the volume of air infused was very small and only possible to identify on cardiac echo. In our patient, the other possible cause was vigorous chest compression and assisted ventilation during resuscitation. Air embolism after resuscitation has often been reported in literature, but this is usually observed in the cerebral vasculature. Systemic air embolism has been reported in premature infants on artificial ventilation as a result of barotrauma, as well as after necrotizing enterocolitis. There is only a single case report in literature where systemic air embolism in a preterm neonate occurred who collapsed suddenly due to a clot in the inferior vena cava. It is hypothesized that there is disruption of pulmonary vasculature during resuscitation, which leads to air entry from the alveoli, possibly because of frail tissues and vasculature in newborns. However, the role of pneumothorax is not clear. There are reports of systemic air embolism associated with assisted ventilation in preterm infants. An early suspicion of diagnosis, urgent echo at the time of collapse, and initiation of treatment for systemic air embolism may play a role in saving life in such a scenario. Medical equipment should also be critically checked at regular intervals by the relevant electromedical department for any malfunction. These possible explanations may be kept in mind while investigating cause of demise in similar situations. Here is another case report from 2019. Abstract background. Systemic air embolism is a rare but fatal complication in the course of neonatal intensive care patients. Risk factors are ventilatory support or central venous lines. We herein report two cases without a direct link to risk factors and with diverse outcomes. The first patient was a male preterm triplet of 28 weeks gestational age, weighing 1,180 grams, treated with nasal CPAP and supplemental oxygen in the first hours of life. Parenteral fluid supply was administered by a peripheral intravenous catheter. On day 12 of life, an aggravation of the patient's general condition accompanied by livid discoloration of the upper leg and abdomen occurred. Ultrasonography demonstrated presence of intracerebral in the brain, intrarenal, in the kidneys, intraintestinal, in the intestines, and intracardiac air. 12 hours after the initial event, the patient developed necrotizing enterocolitis, warranting abdominal surgery. The further clinical course was complicated by extensive periventricular leukomalacia with cerebral seizures. That's bleeding around the brain with seizures. 9 weeks after the air embolism, the patient died from decompensated congestive cardiomyopathy. That's heart failure due to a failure of the cardiac muscle. Postmortem examination reveals an infarction of the left ventricle. The other patient, a female preterm infant of 27 weeks gestation with a birth weight of 735 grams, was ventilated for 24 hours and then managed on CPAP at Roumare. On the third day of life, a sudden deterioration with acute bradycardia required cardiopulmonary resuscitation, which resulted in a small pneumothorax that resolved spontaneously. Her embolism was a suspected trigger of this episode. Ultrasound examination revealed error in heart, liver and brain. The patient was stabilized and showed no residual findings during the further clinical course. Conclusion: in both cases, a direct cause of air embolism could not be revealed, since common factors did not apply for both patients. Although the precise nature of this complication is not well understood, the contrasting outcomes of the reported neonatal cases is striking. That is air embolism, venous air embolism, possibly, probably, in preterm neonates. Direct cause of air embolism could not be revealed, which is true also of the babies in the Letby series. It's really important that people understand that even if an air embolism had been found on any of the Letby babies during their lives, it may not have been possible to say where that air came from, which is the second hurdle that Darry Evans faces every time he sifts a case, but which he never explains to the judges or the jury. Instead, he uses a methodology of a constellation of signs which is unique to him. This is not the proper practice of medicine. And so far, all the appeal court judges have said is that Darry Evans was qualified to give an opinion. The problem that we have is that the opinion he gave did not come about by any accepted method of diagnosis. He tried out noxious substances to begin with, which the appeal court judges don't mention, and when that didn't work, he settled on air embolism. That's what he said to Rachel Aviv, and that, it seems, was the nature of the sifting exercise. So the mystery continues, as far as I'm concerned, from one doctor to another. Unlike the judges, I have no problem whatsoever about the way that Darry Evans gave his evidence. I think that is utter nonsense. And if people do think that, they're rather childish. I have a problem with the nature of his evidence. Its fundamental essence, quintessentially, as Justice Goss might say. And unlike Darry, I think the truth of what went on in the Countess of Chester Hospital is gradually coming to light, and that a new trial would very likely come to a completely different conclusion. So I hope you've learned something from this. I continue to learn about the way that these judges think and the things that they say. I find it all very alien and weird, this whole process, and it certainly wouldn't work in medicine. So we'll finish off here, and we'll see you in the next episode where we'll pick up paragraph 118. Bye.